Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode 80, we're going to look at a recent memorandum from the IRS Office of Chief Counsel. That memorandum is going to illustrate a very established point that I think flies under the radar, but I think is worth mentioning in light of this memorandum, and that's that gift tax is determined not by change of ownership, but instead by the release of dominion or control. Now, as always, this presentation is not intended to substitute for legal or tax advice. Now, this is a timely discussion because we have a lot of people who are trying to gift in trust, but I think it's worth noting that a lot of people assume that change of ownership is really what drives gift tax, but that's not necessarily the case. You can have a gift even if property is transferred that you don't own. And this is reflected often in trust, and I'm going to illustrate some situations where a trustee owns assets, but a beneficiary has a beneficial interest and is treated as making a gift of that beneficial interest. So here's some random examples from past rulings. One would be maybe a situation where a beneficiary has a lifetime general power of appointment, such as a crummy right to withdraw assets, and then releases that right or allows it to lapse, which would be treated as a gift of the assets over which that power of appointment was held. Another example would be a situation where maybe a beneficiary is deemed to transfer a beneficial interest in trust, perhaps by signing a non-judicial settlement agreement that modifies a trust. Another example could be a situation where maybe a beneficiary has the right to receive all income of a trust, but also has a lifetime special power of appointment and exercises that special power of appointment, which would be treated as a gift of that income interest. So the big picture here is that the measuring stick for the imposition of the gift tax isn't a change in ownership, but instead is a relinquishment of dominion or control over trust assets. So you can make a gift of assets that you never even own on paper. But when the overall property rights give you dominion or control over those property rights, then that transfer will be a taxable transfer for gift tax purposes. Now, the big power that allows you to avoid this is known as a disclaimer. Now, a disclaimer on its face is just simply a beneficiary's right to say no to the receipt of a beneficial interest or to the receipt of a power of appointment, so long as certain requirements are met. And if those requirements are met, this would be treated as a qualified disclaimer, and the act of disclaiming would not be a gift for gift tax purposes. So, those requirements include, in part, this isn't an all-inclusive list, but include a situation where maybe the beneficiary does not accept the benefits or dominion or control of the property, and where the property passes without the direction of the beneficiary as a result of the disclaimer. So a better way to think of that second bullet point is that the beneficiary, by the act of disclaiming, is treated as being deceased prior to the initial transfer, so that the beneficiary can never have dominion or control or direction over how the property is going to pass. And then there's a time limitation where 9 or fewer months must have passed since the initial transfer, or if later, since the beneficiary attained the age of 21. So those are just a few of the requirements, but those are relevant to today's discussion, which kind of gets outside of trusts but illustrates these principles nonetheless. That's under IRS Chief Counsel Advice 2020-45011. In this memorandum, the IRS Office of Chief Counsel looked at a situation where you had a taxpayer who was a U.S. resident, and that taxpayer was the beneficiary of a foreign foundation. And what happened is the board of that foundation resolved to transfer the remaining foundation assets to the taxpayer, and the taxpayer was named as the primary beneficiary of this foundation under its various bylaws and other organizational documents, which had been changed over time. Now, one quick note I want to note here is that this is a U.S. resident, but U.S. citizens and residents are subject to U.S. gift tax on worldwide assets, including accounts that might be of a foreign foundation in another country, but nonetheless could be subject to U.S. gift tax. So that's a little hint as to where we're going. And what happened here is that the taxpayer, after receiving notice from the board, instead gave written instructions to the board to send the funds from the foundation's account, which was labeled as account 1, onto another account called account 2. And notably, with account 2, the taxpayer in this case was not the owner of that account and had no power to withdraw the funds once they were in this account. So that account was for other beneficiaries other than the taxpayer. So this came to the Office of Chief Counsel based on a gift tax examination, hashing out some of these issues. And what the Office of Chief Counsel concluded is that as a result of the board resolution, the minute that resolution hit, the taxpayer had dominion and control over the foundation's account, which was labeled account 1. So as a result, once the taxpayer directed the board to send those assets to account 2, that was a release of dominion or control by the taxpayer over account 1, which resulted in a taxable gift. And in addition, since the transfer to account 2 was at the direction of the taxpayer, it couldn't be a qualified disclaimer, because remember, a qualified disclaimer requires the disclaimed property to pass without the direction of the disclaimant. So this was a taxable gift, not a disclaimer, and even though it was a foreign account, the U.S. resident had U.S. gift tax on that account. So, as always, keep in mind that the U.S. gift tax is driven not by a change of ownership, but instead by the relinquishment of dominion or control. And to wrap up, I want to give you a final example where you have a situation maybe where a trust is funded, but the trust transfer is not subject to gift tax. So that might be the case with a revocable trust, or increasingly with an irrevocable trust, which is an incomplete gift trust. That's a situation you see a lot with what are known as nings and dings. Those are trusts that are irrevocable and are created in order to avoid state income tax by being administered in a no income tax state like Nevada or Delaware or somewhere like that. But since the upfront transfer is an incomplete gift, the determination that gets us there is the fact that the grantor retains dominion or control over those gifted assets once they're in the irrevocable trust. But once a distribution is made from that trust to a beneficiary other than the grantor, at that point, the grantor is treated as releasing dominion or control, and that distribution would result in gift tax, which is kind of a big picture issue that has to be resolved in these types of trusts. As always, if you have questions or topic suggestions, you can email me at griffin.bridgers@gmail.com. Thank you for listening to this episode of The 10th of an Hour, and I look forward to seeing you in the next one.